So I was thinking about preparing a flowchart for my students to understand who is deemed rehabilitated. And I thought it's not a bad idea if I prepare a video and explain this. So first of all, rehabilitation is about criminal inadmissibility to Canada. If somebody is criminally inadmissible to Canada, then they could travel to Canada and they could be considered not inadmissible if they are deemed rehabilitated. That's one option, of course. In certain circumstances, we need a record suspension or we need an application for rehabilitation. What does this mean? This means that if you are deemed rehabilitated, then when you apply for immigration to Canada or visa to Canada, you do not really need to apply for an application to remove your inadmissibility to Canada. All you need to do is to submit enough documents to prove to the immigration officer that you are deemed rehabilitated and you are not inadmissible to Canada anymore. So let's take a look at this flowchart, and it explains under what circumstances you are deemed rehabilitated. The first step is to ask yourself whether the conviction was inside Canada or outside Canada. If the conviction is inside Canada, then rehabilitation is not an option. You need to go through the court system in Canada and either receive an acquittal or a record suspension. Acquittal means that the system tells you that you are not convicted anymore and maybe the original conviction was a mistake in the first place. But if they believe that the conviction was okay, but they accept to remove your name from the criminal records of RCMP, then you receive a record suspension, and in that situation you are not inadmissible to Canada. So for convictions inside Canada, the only direction would be acquittal or record suspension. But what if the conviction was not outside Canada? Then you need to ask yourself whether you are charged but no convictions at all. If you have not received a conviction yet, but you are charged by a prosecutor outside Canada, then your best bet is to try to resolve that issue through the foreign court first, because being charged outside Canada and leave it open could result into inadmissibility to Canada. And unfortunately, because you have not resolved that issue outside Canada, there is no guarantee that you can travel or immigrate to Canada. However, if you don't have a charge, but you actually have a conviction, then the question is that, is this a summary conviction? If we find the equivalency of that inside Canada, or an indictable conviction. Generally speaking, summary convictions are less severe than indictable convictions. For example, this means that usually, not always, the term of imprisonment is less than 6 months. And also you don't have a jury right. Usually a judge in Canada makes a decision about the case. So if we are dealing with summary convictions outside Canada, which the equivalency is also pure summary conviction inside Canada, then if a person has received only one summary conviction in our lives and no indictment, nothing else, then they are not inadmissible to Canada. But if there are two summary convictions, then you need to see if at least 5 years has passed since the time that you completed your sentence, pay the fines, everything else. In that situation, you are deemed rehabilitated. Unfortunately, below 5 years, you are not deemed rehabilitation, and your only option is a temporary resident permit. You cannot simply immigrate to Canada. But if you do not have two summary convictions, but in fact you have one indictable conviction, then in that situation, you only are deemed rehabilitated if at least 10 years has passed since the day that you completed all the sentences and pay all the fines. So this is only when you have only one indictable conviction in all your life, and that indictable conviction is not considered serious criminality. In other words, if you find the equivalency of that criminal offense in Canadian law, the maximum term of imprisonment is definitely less than 10 years. However, if you have an indictable conviction that the term of imprisonment is more than 10 years, the maximum term of imprisonment in Canadian laws is more than 10 years, or if you have multiple indictable convictions, in this situation, you never become deemed rehabilitated. What you need to do in those situations is that you need to wait at least 5 years from the day that you complete the sentence and pay the fines to apply for rehabilitation, which that is a completely complex process, and you will probably end up paying anywhere between $200 to $1,000 in processing fee, submit several documents, and request from the immigration officer to consider you rehabilitated. But the deemed rehabilitation is not an option. And again, I repeat, deemed rehabilitation, it means that your criminality is over from the point of view of Canadian immigration system.